Greetings. In this mini lecture on the Supreme Court, I want to talk about how presidents decide who to nominate for the Supreme Court. And I got to one of these four in the last mini lecture when I talked about policy preferences. Typically, this has been the most important criteria for the nomination of Supreme Court justices. Remember, presidents want to nominate justices who view the Constitution, view the law the way they do. And presidents want to have a long term legacy over the court. Now, there is a problem with policy preferences that I did not mention in the last mini lecture, and I'm stealing this from Bill Clinton. When he was president, he was asked about policy preferences, and he said, presidents have to be really careful with policy preferences because the temptation is to look for justices who agree with you on whatever the hot button issues are today. So let's say that there are three really hot button issues that are before the country right now. They're going to head to the Supreme Court soon. And the problem is, if you put a Supreme Court justice on the court, let's call them policy areas A, B, and C. Let's say the president interviews the justice tells the president what he wants to hear on these three issues. That's fine, but the problem is that let's say in the first 2 years of the court, they hear all three of those cases, they're decided, and now you have a person on the court that you have placed there to deal with three issues. Those issues are now resolved, and now that justice may be on the court another 10 years, 20 years, 30 years. And of course, because you only place that person there to deal with specific policy areas, now you have no idea whether that justice may be a wild card on other issues. So Bill Clinton's advice was, instead of looking at specific policy areas, look for broad constitutional themes. For example, I gave you one in the last section on federalism. A president might say, how do you judge Article 6, the Supremacy Clause, or Article 1, Section 8, the Necessary and Proper Clause, when it seems to run contradictory to the 10th Amendment? And even though this may not give you insights into 100% of federalism cases, really, I told you that the battleground in federalism has typically been Article 6 or Article 1, Section 8 if you're a nation-centered federalist, or the 10th Amendment if you're a state-centered federalist. And that will probably give you the answer in most cases. So Clinton's advice is stay away. Maybe not stay away. That's an exaggeration. Do not only look at specific policy preferences. Also look at broader constitutional themes and controversies that have lasted for a long, long time. The second thing that might prompt a president to nominate someone for the Supreme Court is what I would call competence and ethics. Every nominee to the Supreme Court is ranked by the American Bar Association as being either well qualified, qualified, or not qualified. As you might guess, it is typical whether the Supreme Court justice is really liberal. Ruth Bader Ginsburg was ranked unanimously well qualified. Or really conservative, like Antonin Scalia. He was ranked unanimously well qualified. You would expect that. After all, these people are being nominated to the highest court in the land. The last justice that had a problem in both areas at the same time was Clarence Thomas, and I mentioned that in the notes. When Clarence Thomas was nominated by George Bush Sr. to replace Thurgood Marshall, none of the panelists on the American Bar Association ranked Judge Thomas well qualified. And for the first time that I ever remember, two panelists ranked him not qualified. So there was a real question about Clarence Thomas's competence. Before that could really be explored, An explosive allegation was alleged by Anita Hill. Anita Hill was a University of Oklahoma law professor, but at one time she worked for Clarence Thomas at the Equal Employment Opportunity Commission. Uh, Anita Hill, Professor Hill, alleged that Justice Thomas sexually harassed her when he was her supervisor at the EEOC. The details were very, very lurid, and I won't get into them on the tape, but essentially the allegations were that Judge Thomas was addicted to pornography and that he had sexually harassed her on multiple occasions. He claimed that she had pursued him, he had rejected her, he had married another woman. This was the revenge of a scorned woman. The confirmation essentially boiled down to who you believed, and the confirmation vote was incredibly close. In fact, it was the closest confirmation vote in the Senate in more than 50 years. And Clarence Thomas was confirmed by the Senate 52 to 48. So no Anita Hill. I will put a question into the test bank. Who was the woman who accused Clarence Thomas of sexual harassment in the Senate Judiciary Committee hearings? Now, the third thing that might prompt a president to nominate a Supreme Court justice is political reward, political support. I get very frustrated by this one personally because when conservative presidents do this, liberals go crazy. When liberal presidents do this, conservatives go crazy. Both sides allege that the other side does this. In reality, they both do. And to me, it shouldn't be a big deal at all. We've already established that the Supreme Court is a very political institution. So why wouldn't a president, assuming that the justice has the policy preferences, assuming the justice is competent, assuming the justice is ethical, why wouldn't a president try to enhance their political prospects through a nomination? So I gave you two examples in the notes. Ronald Reagan, interestingly enough, when he was elected president in 1980, for the first time, we began speaking about a so-called gender gap. A gender gap. That is to say, men perceived Ronald Reagan much more favorably than women. Reagan's advisors went to him, said, "Mr. President, we have an image problem with American women." Reagan said, "Well, is there anything that I can do to help?" And they go, "Yeah, but we don't think you're going to like it." And they told him that we suggest you make history, Mr. President. You be the first president to nominate a woman to the high court. And that's what Reagan did. Reagan nominated Sandra Day O'Connor, but Sandra Day O'Connor did see the world much as Ronald Reagan did, although on social policy she was a little more liberal. She was highly competent, highly ethical. She even had real world experience as the first woman to serve as a majority leader in a state legislature. So she checked all the boxes, but did Reagan hope that nominating Sandra Day O'Connor would help him politically when he ran for re-election? Of course. Did it? I don't think it really helped or hurt. Now, the same thing happened with Barack Obama when he nominated Sonia Sotomayor, the first Latina to the court. Critics said he's doing this for political reasons, but once again, Sotomayor checked off all the other boxes. She saw the world much the way Barack Obama did, maybe a little bit more liberal than Obama. Highly competent, Sotomayor had more experience on the U.S. Court of Appeals than any of the other justices that are currently on the Supreme Court. Highly ethical, no skeletons in the closet. Did Obama help that this would help him at election time? Of course, he was hoping that this nomination would help him. Did it? I don't think it really helped very much at all. But once again, she checked off all the boxes. So in my mind, both Reagan and Obama should have nominated these people because they checked off all the boxes. The last thing, and here you're going to need to turn to the next page, because I put this on the next page with deciding a case, and I probably made a mistake. I probably should have put this on the page with the first three. So make sure you go to the next page and look at this section in your notes. Judicial philosophy is not what most commentators say it is. Most commentators say that judges who believe in judicial restraint are conservative, and those who believe in judicial activism are liberal. It's not true. In fact, if you take a look, it's about the same, maybe even slightly the other way around. If you look at the period since World War II, you can find about as many liberals who believe in restraint and activism as conservatives. This is not about political ideology, it's about how the justices view their role. So you should know both of these for exam purposes. Judges who believe in judicial restraint, underline the first sentence. These justices believe that the courts should defer to popularly elected institutions of government. A former Supreme Court justice who believed in judicial restraint once said, if the legislature wants to go to hell, I'm here to tell them they can do it. Right? The idea here is that in a republic like the United States, we elect representatives to make laws for us. We elect city council people. We elect state assembly people. We elect congresspersons. The judges who believe in judicial restraint say we should respect the popularly elected institutions, that we as judges should strike down laws as seldom as possible, and we should do so on as narrow a basis as possible. If you want to go back to that initial paradox of democracy that I started the course off, these judges tend to stress majority rule, that people, majorities, elect representatives to make the laws for them. We as judges should respect the rule of the majority. Now, clearly, if they step way out of bounds, we need to bring them back on the playing field. But if it's borderline, we should let it go. The other justices stress judicial activism. These justices believe that the courts should be a tool to protect oppressed minorities from majoritarian tyranny. This view stresses minority rights. A former lower court justice who believed in judicial activism said that when I look at a case, I ask myself one simple question: does the law make you sick? And if it does, you have a moral duty to overturn that law. The judge went on to say that the entire government, city council, state legislatures, Congress, mayors, governors, presidents, all of them are subject to the pressures of the majority. The only institution that is capable in American government of providing a balance between majority rule and minority rights are the courts. And therefore, it is the courts that should be the bastion. The courts should be the tool. They are the only ones who, on a consistent basis, can protect oppressed minorities from majoritarian tyranny. And therefore, that is what we should do. As justices, we should protect minority rights from majoritarian tyranny. So do not think of judicial restraint and judicial activism as, quote, conservative or liberal. Think about these judges as those who have a preference for majority rule, those who advocate restraint, or judicial activism for those who are advocates for minority rights. In the next lecture, we will finally get into deciding a Supreme Court case, and here I think it gets kind of intriguing. Hope you're having a great day, everyone. Have a good day.